What up, YouTube? Here again, Informatory Product with another informative video. Not to give legal advice, but to give education. Okay, this is not legal advice. It's for educational purpose only. It's to help people to understand and how to discern what they read or what they're reading. Okay, this is a case law. Barbour, I don't know if I'm pronouncing it right, Barbour or Barbour versus Walker. Okay, 1927. Okay, I'm about to prove once again that we are being labeled as carriers. Okay? Okay, just carriers, period. Whether you're a private carrier or a common traveler, however you see it, you know, you have to be regulated, by legislation. Basically, the state has the right to regulate, your automobile, your vehicle, if you're labeling yourself as a carrier or if you identify yourself as a carrier. Okay? This should just end it once and for all. Okay? If people don't understand after this one, then I don't know what to say. Okay, I'm about to break it down to the most simplest form I could possibly, break it down. Okay. Okay, you got carriers and you got private motor carriers. Okay? For hire. Okay? For hire. Okay? Let's start with this one. Carrier. Constitutionality of statute regulating use of highways by motor carriers for hire. Okay? Chapter 113, SL 1923, providing for the regulation of the use of the public highways of the state by motor carriers for hire through the limitations of that use by the rule of public convenience and necessity. It is a valid and constitutional exercise of the police power of the state to promote the public good, to preserve the public peace, and to protect the public welfare. And said act is not contravention of any rights of the citizen guaranteed to him by the 14th Amendment to the Constitution of the United States, nor by Section 7 of Article 2 of the Constitution of Oklahoma. Okay, 2. Same, which is the same as this one, guys. Okay, same, except that it would be a private motor carrier for hire. Okay, same, private motor carrier for hire, subject to regulatory statute. A private motor carrier operating over the public highways of the state, though without regular or fixed time schedules between fixed points in the transportation of commodities for hire under separate contracts with several principal business concerns located and doing business in one of such points, is a motor carrier within the meaning of Chapter 113 SL 1923 and is subject to control and regulation by the provisions of law therein provided. So basically, this is a case where it's not the state versus, an individual. Basically, I believe this is two individuals or one individual versus another individual, claiming that the plaintiff is an individual. Let me see where this is. Okay, Barbour is the plaintiff and Walker is the defendant. So Barbour is actually put a petition in, a temporary injunction based upon the petition wherein the plaintiff's substance alleged that they were motor carriers for hire engaged in transportation commodities between the cities of Oklahoma and Shawnee, however you pronounce it, over State Highway number 3, for which purposes they had secured a proper certificate of public convenience and necessity from the State Corporation Commission and had paid the proper license fee and had otherwise complied with the provisions of Chapter 113 SL 1923, regulating the use of motor carriers for hire upon the highways of the state, that defendants were likewise operating motor carriers between said points and over the same route without having secured from the State Corporation Commission a certificate of public convenience and necessity, and were otherwise operating without compliance with the provision of said Chapter 113, and that thus they were operating in competition with plaintiff and depriving them of revenue, which is injury, to which they were justly entitled by virtue of their compliance with said 113, that defendants' operation of their motor carrier constitutes a public nuisance. So basically they're saying that since they're claiming that Walker did not basically they did not where is this at? They did not secure, basically they're claiming that they did not secure a proper certificate of public convenience and necessity from the State Corporation Commission, right? So basically they're saying that, and thus they were operating competition with the plaintiff and depriving them of revenue to which they were justly entitled by virtue of their compliance with said Chapter 113. The defendant's operation of their motor carriers constitutes a public nuisance and a menace to the common user of said highway, and an imposition on the just and lawful rights of plaintiff, by reason whereof plaintiff's business suffered irreparable damage and injury, for the redress of which by reason of defendant's insolvency plaintiffs were without an adequate remedy at law, wherefore they prayed a permanent injunction against said defendants. So they're claiming that the defendants are using their route, the same route that they signed up for as a carrier, a constitutional of statute regulating use of highway by a motor carrier for hire. That's what they're claiming. And they're claiming that these guys is not obeying the rules and regulations that was I guess that should be enforced by the commission. Okay, so the defendants answered by admitting the allegations of plaintiff's petition, but denied infraction of the laws as alleged. They further answered that they were associated in the transportation of freight and merchandise between the points mentioned under separate contracts with 5 individuals and firms in Oklahoma City, that they did not hold themselves out to the public as common carriers, nor did they intend to solicit other business from other persons, that such freight and merchandise was transported to the city of Shawnee for their employers, either for storage in storage plants furnished by said defendants for redelivery when sold, or originally to purchasers of said commodities doing business in the city of Shawnee, and that they were so operating without any regular or fixed time schedules, that being operators as private carriers, they were not subject to the provisions of said Chapter 113, wherefore they prayed denial of plaintiff's petition. Upon demurrer, that part of their answer relating to storage of commodities was stricken. Okay, so they admitted that they was operators of private carriers, which is a private business. They're still in commerce, right? Whether you're private or public, you're still in commerce. Okay, but the problem is you have to know what we should know what an operator really is and what does it consist of. Okay. Upon hearing both parties introduce evidence in the substantiation of their respective pleas, it further developed that the concerns with which the defendant held contracts were of the principal business houses engaged in their respective line of commodities in Oklahoma. The court found the issues for the plaintiffs and a judge that they were entitled to a temporary injunction pending a further order of the court, to which the judgment defendants accepted, and upon superseding said judgment brought the case here for review. Okay, in the trial of the case, plaintiff contended that as holders of certificate of public convenience and necessity, they were entitled to injunctive relief. That Chapter 113 was broad enough to and did include all persons operating motor trucks for hire in the manner alleged, whether such persons were engaged as common carriers or as private carriers. See that? Common carrier or private carriers. Defendants contend that the act does not regulate private carriers nor engage as common carriers. Okay? So the defendant contended that the act does not regulate private carriers as common carriers, which he was wrong. I don't care if you're private or common. If you're engaging in commerce, you have to be regulated. Okay? The judgment of the court in granting the temporary injunction was in effect a determination that defendants were in fact motor carriers within the meaning of Chapter 113 and were thus subject to control and regulation thereby. You see? Okay. In this court, defendants for reversal of judgment contends first that they are private carriers. See, they admitted that they were private carriers and that as such they are not within the purview of Chapter 113 SL 1923. And second, that if said Chapter 113 is operative as to them, the said act is unconstitutional and void as in violation of their rights under the 14th Amendment to the Constitution of the United States and under Section 7 of Article 2 of the State Constitution. We will consider these contingents together as they may be properly resolved into one general proposition, namely, that defendants have the right as proper motor carriers to use the public highways of the state for private enterprise and profit without let, hindrance, or interference from the public authorities of the state. You see, guys? They held themselves out as private motor carriers, right? So if you're going to use it for gain, you have to abide by the rules and regulations, okay? But first, they have to prove that you're using it for gain, whether private or common, okay? The unconstitutionality of Chapter 113 has therefore heretofore received consideration by this court in the case of Ex parte Tyndall. Okay, if I said that right. Okay, 102 Oklahoma 192 229p.125. The law was there challenged on the identical grounds here relied on. Upon a thorough analysis of the act, which need not here be reiterated, its validity was sustained. In addition to what was there said as to the purpose and necessity of the law, we may here well observe that prior to the advent of automotive power, regulation of the use of the public highways was not essentially required, as no phase of the public welfare as either inconvenienced or exposed to danger as now. So it's a lot of people now, so we are really exposed to danger. Though they were used for both common travel, okay guys, and private gain, particularly between points where there were no railroad facilities. Okay, this is the beginning of it. Construction and maintenance of the highways then were left to county and township organizations with the financial means therefore raised largely, if not altogether, by local taxation. Public use thereof was not as marked then as now, for the traveling public found inconvenient to pass to their destination by means of travel by rail rather than by horse-powered vehicle. With the advent of the automobile, our mode of travel was transformed in less than a decade. This transformation required a change in our system of highway construction from that of the ordinary improvised dirt road to that of highly improved and hard surface road. So basically all the roads, the hard pavement roads, it's really basically it's for commerce use. But I would think the common people have a right to use that, being that it is the land. Okay, let's keep reading. This accelerated the establishment of our state highway department, whereunder we are now expending millions of dollars annually to meet the requirements of the traveling public. Okay, when they mean traveling, they mean traveling in commerce, guys. Okay, so it could be a problem. Speed laws were found to be necessary to maintain order and to minimize danger in the use of the highways, in addition to the primary purposes, that of a combination of the traveling public in the common acceptation of the term, utilization of our highways constructed and maintained at large public expenses by transportation, that word again, by transportation thereof of both passengers and property for private gain, developed even between points where railroad facilities were available, and on that scale where regulations of the use of our highways for private enterprise became a necessary function of government. For if not so regulated, appropriations, therefore, for private purposes, would eventually place the public in the position of furnishing the highways for private enterprise rather than for public purposes for which they were established. Okay? Here's the good part. To obviate this condition rapidly materializing, the legislature, in its wisdom in protection of the public welfare, enacted Chapter 113 and other provisions of law not here necessary to notice. The law is based upon the theory that the individual citizen has not vested rights to use the highway of the state for private enterprise to detriment of the general public, and that where the individual interest conflicts with the public interest, as must be the necessary result in the use of the public highways for private purposes without regulation, the government is never impotent to protect the public welfare. The principle applied to the regulation of the use of the highways for private enterprise rests upon public convenience and public necessity, a principle organized and in large degree applied by the national government in placing the control and regulation of the railroads of the country in the hands of Interstate Commerce Commission. Title 49, the Transportation. Guys, Chapter 1, Section 1, U.S.C., 1926, 44 Statute, 1649, okay? I'm not going to read all of them, but I'm going to go through a few of them. It was upon this theory and the application of this principle that this court in Ex parte Tandao held that the state was within the rightful exercise of its police power in the regulation of the use of the highways in sustaining the constitutionality of the law here again challenged, and denied that it in any wise was in contravention of either the 14th Amendment of the Federal Constitution as in abridgment of any right or privilege of the citizen, or in deprivation of property without due process of law, or in denial to the citizen of the equal protection of the law, or of Section 7, Article 2 of the State Constitution on the same subject. It was there also held that the real purpose of the act was to regulate the use of the public highways by transportation companies through the regulation and control of who? Motor vehicles operating as common carriers for hire and profit over the public highways, and that, in quote, the operation of motor vehicles for the purpose of carrying passengers and freight for hire and profit over the public highways as a transportation roadbed is a public service enterprise within the constitutional definition of such enterprise and as such subject to regulation and control by the state. Okay, guys. All right. Let's get to the good part. Okay. All right. We're going to start from the top. Let's just say I was pulled over for speeding. Okay. And they're allowed to arrest an individual without a warrant. And here's their authority to do so. Okay. Arrest without warrant authorized. Okay. Let's look through the provisions real quick. Persons arrested to be taken before a magistrate. Okay. Notice to appear. Okay. Once you get arrested and they go through all the the chitter chatter, they're going to issue you a ticket, a citation, to give you a notice to appear. Right? And if they don't take you to jail, they give you a notice to appear. All right? When they don't take you to jail before a magistrate. Okay? You have to do your own reading now. I'm just trying to get through this real quick. Notice to appear required in certain offenses. An officer shall issue a written notice to appear if the offense is charged speeding, right? Let's just say if I was pulled over for speeding, okay, they would have to give me a notice to appear, right? I'm going to have to sign a promise to appear. To secure release, the person arrested must make a written promise to appear in court by signing a written notice prepared, okay? You get that? Written notice to prepare by the arresting officer, okay? Okay, and I get the ticket and what he's going to put on there, the time and the place for my appearance, correct? Correct. The time specific in the notice to appear must be at least 10 days after the date of arrest unless the person arrested demands an earlier hearing, okay? And he hands you the notice to appear, okay? The notice to appear, commercial vehicle, okay? Or a license. So if you're not in a commercial vehicle, you may just give him, may as well give him a license, right? Commercial vehicle or license. So it doesn't matter if you're in a commercial vehicle or not. If you give him a license, you're still a commercial vehicle, okay? Let's go on to read. A notice to appear issued to the operator of a commercial vehicle, commercial motor vehicle, or holder of a commercial driver's license or commercial learner's permit for the violation of the law regulating the operations of vehicle on the highways must, you hear that? Must contain the information required by department rule to comply with Chapter 22 and the Federal Commercial Motor Vehicle Safety Act, Title 18, Act of 1986. Again, Title who? 49. Okay? Remember that. Please remember all my highlighted words, or try to. Okay? Okay. Let's go back. Must contain the information required by the department rule to comply with Rule 522. Okay? That means it must contain information, all right? Let's go here. Let's go to 522. Oh, 522. Commercial driver's license. Okay. It means you got to have a driver's license, right? You have to be compliant. You have to be in compliance with 522. You have a person identification card or you have a driver's license. But see, what they're not showing up here, this driver's license really means commercial driver license, all right? So let's just say if you was in let's just say a Honda Prius. Let's just say a Honda CR-V. You get pulled over, right? That would, then you will, if you was to present a driver license, you would be, most of us will be presenting a Class C, which is still a CDL driver's license. Okay, and here's the proof for that. Okay. Okay. First of all, let's go here. Commercial motor vehicle means a what? A motor vehicle. Okay. Just because they don't use the word commercial doesn't mean they're not meaning commercial. They're just using the definition word of commercial vehicle. Okay. A shorter version. All right, let's go. Let me see. Let's see. Bear with me here, guys. Okay, right here. Classification. Okay. You got your Class A license, your Class B license, and your Class C license, which covers a single vehicle or combination of vehicle not described by subsection B or C, either one of these. That is, one, designed to transport 16 to 23 passengers, okay, including the driver, or used in the transportation of hazardous materials that require the vehicle to be place carded under 49 CFR Part 172, Subpart F. Okay, 49 CFR. Y'all remember that. Again, Class C covers that and covers that. Okay. Let's move on. Speed signs. The department shall erect and maintain on the highways and roads of this state appropriate signs to show the maximum lawful speed for commercial motor vehicles. Okay. Commercial motor vehicles, truck, trailer, truck tractors, truck trailers, truck semi-trailers, and motor vehicles. Okay. Motor vehicles again. Commercial motor vehicles means motor vehicle. Engaged in the business of transporting passengers for compensation or hire. Okay. Okay. All right, let's move on. Okay. A motor carrier. The term motor carrier means a person providing motor vehicle. Okay. Motor vehicle again. Commercial motor vehicle. Transportation for compensation. Okay. For compensation. Okay. For compensation, where we at? You got a motor carrier, then you have the private motor carrier. Remember, guys? Okay, let's go here. Carriers. Private carriers. Okay. Carriers. Private carriers. Okay. All right. We know what motor vehicle means. Propelled. Drawn. Okay. And. Okay. So I went to the Texas Department of Public Safety to look up the driver's license. How do I apply for a driver's license? This is what I came up with. Class A, B, C. Permits the holders to operate any single vehicle or combination of vehicle that is not a Class A or B if the vehicle is designed to transport 16 to 23 passengers and including the driver, okay, or used in part or used in the transportation of hazardous materials, okay? Let's move it on. Motor carriers that transport hazardous materials in interstate commerce. Okay, this is the rules in the following provision of this chapter apply to motor carriers that transport hazardous materials in interstate commerce, and to the motor vehicles that transport hazardous materials in intrastate commerce. Okay, however you see this, it's a motor carrier. All right, let's move on. Title 49. Yeah, remember that. Title 49, USC. Okay. Title 49. Okay. Motor carriers. Motor carriers. Okay, let's move on. All right. One-on-one. Purpose. We're going well. Title 49. Department of Transportation, the very first title. Okay. Let's see what their purpose is. Okay. One-on-one. Purpose. The national objectives of general welfare, economic growth, and stability and security of the United States require the development of transportation policies and programs that contribute to providing fast, safe, efficient, and convenient transportation at the lowest cost for hire, consistent with those and other national objectives, including the efficient use and conservation of the resources of the United States. Okay, the purpose. All right, let's move on. All right, the powers and duties. Okay, Federal Motor Carrier Safety Administration. Okay, powers and duties. The administrator shall carry out duties and powers related to who? Motor carriers or motor carrier safety vested in the Secretary by Chapter 5, 51, 55, 57, 59, 133 through 149, 311, 313, 315, and 317, and by Section 18 of the Noise Control Act of 1972. Okay? Here's where we're going. Powers and duties, okay? 313. Remember that. All right, we're going to go to 313. Let's go here first. Okay, we're going to go to 313. All right. 313. Okay. 49 USC 313. Okay. It's for motor carriers, mind you. Duties and powers and duties. Duties and powers related to who? Motor carriers. 313. 313. Commercial motor vehicle operators. Driver. Okay. Let's go down a little bit more. Commercial motor vehicle means a motor vehicle used in commerce to transport who? Passengers or property. All right. Class A, your Class B, your Class C. The same thing. Okay. Materials, hazardous. Okay. Easy. Okay, let's go here. Employee. Let's go to employer. Means a person, including the United States government, a state, or political subdivision of a state that owns or leases a commercial motor vehicle or assigns employees to operate a commercial motor vehicle. Okay, employee means a operator of a who? Operator of a motor vehicle. I'm gonna leave commercial out of it just because they do. Employee means an operator of a motor vehicle, including an independent contractor when operating a commercial motor vehicle who is employed by an employer. So if a person means United States government or political subdivision or state, and if I sign up at a DMV office, I am signing up to be an employee, and they're going to assign their employees to operate a commercial motor vehicle on the roads. Okay, motor vehicle means a vehicle that is self-propelled. Okay, rented CMVs and leased passenger carrying CMVs, a motor carrier operating a who? Self-propelled CMV. Okay, motor vehicle means a self-propelled. Okay, commercial motor vehicle, self-propelled. Okay, let's go move on. Commercial motor vehicle means any self-propelled or towed motor vehicle used on a highway in interstate commerce to transport passengers or property when the vehicle, okay, again, Class A, Class C is designed, let me see that again, has a gross weight rating or gross combination weight rating or gross vehicle weight, gross weight or gross combination weight of 4,536 kilograms, which is 10,000 pounds or more, whichever is greater, or is designed or used to transport more than 8 passengers to who? Transport more than 8 passengers, including a driver, for who? For compensation. Or designed or used to transport more than 15 passengers, including a driver, and it's not used for transportation passengers for compensation. Or, here we go again, hazardous materials. Okay, it's all commercial motor vehicle. Motor carrier, okay, means a for-hire motor carrier or a who? Like a private motor carrier again. The term includes a motor carrier's agent, officers, and representatives, as well as employees responsible for hiring, supervising, training, assigning, okay, assigns. Amazing. Assigning or dispatching of drivers and employees concerned with the installation, inspection, and maintenance of a commercial motor vehicle equipment and or accessories. Okay, for the purposes of this subchapter, the definition includes the term employer and exempt motor carrier. Okay. All right. So I went to dig a little bit deeper. So I stumbled upon a Texas Motor Carrier's Guide to Highway Safety. Okay. Texas Highway Patrol, Commercial Vehicle Enforcement. Okay. You guys pause, do your own reading. I'm just getting to where I need to go. See, this is all commercial driver license. Classes of commercial driver license, Texas Transportation Code 522.41. Let's go to 522.41. 522.41. Right here. 522.41. Classification, guys. Class A, Class B, Class C. Okay. Commercial driver's license. Okay. Commercial driver's license. I'm sorry, commercial driver license. Okay. Now, we're going to end it with the case law that the guy sent me to use to try to back his plight up, I guess, if you will. We're going to run through it real quick, and I'm about to end this video. Okay. Please do your research and do your homework. Okay, this is the case law that the state won against Skirdahl. I believe that's how you pronounce the name. Okay, we're just going to briefly go through it real quick, and I'm going to try to explain a few points. Okay. Skirdahl refuses to procure and carry a driver's license on various constitutional grounds. He raises 28 issues on appeal. We have reduced those to one basic question: were any of Skirdahl's constitutional rights violated? We hold that none of Skirdahl's constitutional rights were violated, and that it is a proper exercise of the state's police power to require a valid driver's license before one may operate a motor vehicle on the public highways in Montana. Okay. Judgment affirmed. It should be noted that here the state was not required to file a response brief. Okay, so I wonder if they would have filed a response, would Guy have won his case? Okay, that's interesting. Because Skirdahl's appellate handwritten brief was not properly filed with this court. Skirdahl appears pro se and former Papyrus, if I said that right. We have accepted Skirdahl's appeal despite its irregularities because it contains frequently raised arguments which need to be finally settled. Okay, we have subdivided Skirdahl's voluminous brief and have organized his various agreement in the following manner. Okay, Skirdahl, the driver's license. Skirdahl asserts that it is unconstitutional for the state to require him to procure a driver's license before operating a motor vehicle on the public highways. According to Skirdahl, it violates his constitutional right to freedom of travel and right to use his private property, his car, without governmental interference. Lastly, he asserts that the state legislature is unconstitutionality, encroaching on his absolute constitutional right, and that the judiciary is blindly accepting these laws and further encroaching on his rights. We disagree. First of all, Skirdahl asserts that it is constitutional for the state to require him to procure a driver's license before operating a motor vehicle is the wrong argument from the jump. Okay? Anybody that argues this point is very unintelligent, very unaware, very uninformed. Okay? Skirdahl's appeal is without merit, and I agree. This court has already ruled on that issue. We have previously recognized the power of the state to regulate license of drivers in the interest of public safety. Okay? License is the best means to determine that drivers meet minimum standard of competence. It is a justifiable, reasonable, and desirable exercise of the police power of the state. And I agree. Okay? All right, let's see. Rights are not absolute. Okay? One must begin with the basic premises that constitutional rights are not always absolute. Rather, they are just constitutional safeguards which must first be met before a government may infringe on an individual's rights. Okay? You get that, guys. Okay? Okay, there's a safeguard in place for that. For example, the private property interests Skirdahl asserts are not absolute. You heard that, right? The private property interests, okay? Skirdahl asserts are not absolute, but the Constitution guarantees that due process will be had before an infringement occurs, which is absolutely right. So whatever happened, he gave up a lot of information, and before they can even infringe on his rights, they have to be due process. So he failed somewhere in there, and we're going to find out where. It's all about the wordplay, guys. Wordplay. It's essential that you learn the meaning of the words that is being used right before you. Okay? This is what Skirdahl calls the encroachment of his absolute right and the judiciary's blind acceptance. However, this is the law in this country. Agreeing with the law is not a prerequisite to following it. Okay? Right to travel, the right to freedom of travel not only is not even implicated in this case. You see that? It's not even implicated. He didn't even apply that he had the right to freedom of travel. But anyway, let's go on. Okay? In this case, it has not been infringed. At no time were there any constraints by the state of Montana on this right of Skirdahl. He has at all times remained free from the state regulations and constraint, able to leave this state and travel as he pleases. He was free to get on a plane and fly to New York, free to take a bus to Wyoming. He existed free of any state interference of this right to travel. This notion of right to travel remains wholly separate from the right or privilege to operate a motor vehicle on the public highways in Montana. Now, why would you say that? Okay. This notion of right to travel remains wholly separate from the right or privilege to operate a motor vehicle on the highway in Montana. Okay. Let me like this one more time. Okay. Being that the notion of right to travel remains wholly separate from the right privilege to operate a motor vehicle on the public highways in Montana. Okay. Operating a motor vehicle, right or privilege. See, that was his whole argument. His whole argument was he should not have to be regulated, being that he have a private motor vehicle. Being that you're stating and admitting that you have a private motor vehicle and you're not proving it without a shadow of doubt through the statutory requirements there is, that's put in place for us to use, you're going to lose. Operating a motor vehicle, right of privilege. Many states have recently debated under similar circumstances whether it is a privilege or a right to drive on the state highways. Predictably, Skirdahl argues that it is an absolute right. We disagree. Skirdahl's arguments was operating a motor vehicle was all right. That's where he went wrong at. Okay? It's not a right. It's a privilege. And anybody argues that is unintelligent or uninformed. The ability to drive a motor vehicle on a public highway is not a fundamental right. Agreed. It is a revocable privilege that is granted upon compliance with statutory, license procedures, Remember, statutory, All right. We're going to go here. Free man. You guys read that. I'm going here. Free man status. We reject Skirdahl's argument that he is a free man, exempt from the laws because he has no contract with either the state or federal government. Skirdahl is a person. Get that, guys? Skirdahl is a person. As defined by 61-103-1307. You guys go look that up if you have to. Montana Code, and bound by the statutes in Montana, which he violated, Skirdahl is a person, Person, in general usage, a human being, i.e. natural person, though by statute, the term may include labor organization, partnership, association, corporation, legal representative, trustees in bankruptcy, or receivers. So being that they're saying that he's bound by statute, and they're calling him a person, they're not saying he's a human being. They're saying he's a corporation. Again, though by statute. By statute now. You don't want to be a person, guys. You guys go ahead and read on. But I'm going to show you why if you don't. I'm about to play the short clip by and show you that if you don't go after this pursuant to statutory requirements, you may lose every time. You have to go in with the right argument if you're going to argue. Okay? I'm going to play this short clip.
This will inevitably reap us huge profits beyond our wildest of expectations and leave every American a contributor to this fraud, which we will call social insurance. Without realizing it, every American will insure us for any loss we may incur, and in this manner, every American will unknowingly be our servant, however begrudgingly. The people will become helpless without any hope for their redemption, and we will employ the high office of the President as our dummy corporation to foment this plot against America. Having established plausible deniability, even if people become enlightened that they had a remedy and pursued it, the attorneys, judges, and legislators could claim that they did not understand the people's claims, especially if the technical requirements for achieving it were not followed pursuant to statutory requirements.